making an effort to blog more frequently. I will be uploading video blogs in addition to my written blogs onto the MJ Space site, where I will talk about current events, updates with my business, technology things, and just random thoughts. But today I have a specific topic that I'm going to have in my first video, and that is the case that some people may know about. It's been getting national attention for over the past couple weeks. Not as much as the Trayvon Martin case, but it's getting up there, and that's the case of Marissa Alexander, who was tried and convicted, I believe in 2010, for firing a warning shot in the vicinity of her abusive husband and their 2 children. So there's been some amount of controversy over this case because many people feel that many of the media reports haven't exactly been complete. So it's kind of been slanted towards, okay, there's a double standard. Why can't she stand her ground? The complete picture, there's like her side of the story and the story that's being promoted in the press, and there's also the actual court documents that have been released in this case that point a broader picture. It may not be as clear cut. She may not be the totally innocent victim that was portrayed, but at the same time, there's the other factor of the prison sentence, which I'm going to say right off the bat is outrageously long, regardless of whether stand your ground applies or not. Like, she's subjected to a 20-year prison sentence, which is, no matter how way you look at it, is quite frankly ridiculous. But let's take a look at the facts that are available to the public, per se. Mrs. Alexander, visited their home, which she hasn't been living in for 2 years. Pretty much they had an order of protection. So essentially she went to this house, which she really wasn't supposed to go to begin with, but she went there because she just recently gave birth to their 3rd child. Broke out when her current husband, which is who has been pretty much repeatedly abusing Mrs. Alexander in the past, found these text messages. So essentially now things have gotten physical. There's no dispute to that from like either side. Like the prosecution in this case, the judge in the case have actually acknowledged that has taken place. Where the complicated issue comes into play is eventually she was able to escape the confrontation, go into the garage where her car was parked, and she had a gun in the car. According to her, she tried to leave, but she didn't have her keys, and she also could not escape through the garage because the garage door wouldn't work. Well, I'm not sure, I am not sure whether that was actually the case or not. But apparently, so she decided to go back in the house, allegedly to go pick up her key so she could go back and leave with her car. During the course of this, she fired a warning shot to ward off her husband, which ultimately led to the charges, saying that she discharged a firearm with intent to harm, or no intent to harm. So aggravated assault with a firearm with no intent to harm, which according to Florida laws, there's essentially a standard that if you use a gun in a crime, you don't shoot it, that's mandatory 10 years minimum. If you use a gun in a crime and you do fire, that's mandatory 20 years. And if you actually hit someone while shooting your gun, then 25 to life. Now we're at 20 years because she discharged her firearm. Essentially, there's 3 victims in the case, alleged victims in the case, her husband and her 2 children. So the argument was that since she went back into the house, stand your ground does not apply. Since she wasn't being attacked at that exact moment, stand your ground doesn't apply. And I would be willing to entertain the possibility that yes, that argument made by the judge and the prosecutors was actually correct, that stand your ground doesn't apply in this case. She wasn't being attacked at the time that she fired her weapon, and she wasn't in a case where stand your ground would apply and begin with, because, well, okay, if she really was scared because she had just recently mind to say, okay, I don't actually have to get my keys and get in the car and drive off. I can jump out the window or go to the front door. I'm actually of the opinion that even if she could have did that, it's pretty understandable that she didn't. That's not enough to warrant prosecuting her for something that would warrant 20 years. The second case is that she did fire her weapon, but she, didn't intend to hit anyone. She just discharged her weapon. If the prosecutors did believe that she intended to hit someone, then they would have charged her with a much more serious offense, such as assault with the intent to harm, or attempted murder, or attempted manslaughter, or something like that. But you can still hit someone. The bullet can ricochet. You're firing in the vicinity of kids, which is something that I would say was pretty, why would you do that? There wasn't a situation where you were in imminent state of imminent danger that would warrant discharging your weapon. So I can actually agree that, hey, maybe a guilty verdict is something that is appropriate here. But then we get to the case of, okay, now go forth. Instead, she's facing a 20-year sentence, considering she spent 2 years, that would be an 18-year sentence, so she'll be almost 50 by the time she gets out, and it doesn't seem reasonable to me at all. But then there's the other aspect of, okay, she was offered a plea of a 3-year sentence, which in hindsight, maybe she should have taken. But considering the fact that the actual crime would deserve, as opposed to offering something, as opposed to going to trial and doing something well in excess of what the crime deserves, it doesn't seem very like a reasonable act on the part of the prosecution. Like, if you're trying to dispose of a case, you offer something less than what you feel the actual crime would merit, but you don't just have the potential of over-the-top sentence to discourage someone from defending themselves in court. That doesn't seem right to me. But in any case, she was found guilty just recently. Her motion for a new trial was denied. So where are we now? Well, she has a few options. She can appeal, which I seriously doubt that's going to happen. I don't think that will get anywhere. From a legal standpoint, there isn't enough to warrant a new trial, purely from a legal standpoint. There wasn't enough to warrant a retrial to begin with. There's enough evidence to prove that she was guilty of the crime. The mandatory minimum sentence is legislatively imposed, not court imposed. So in order to change that, you have to go through the legislative process or through the governor. So I would to allow for a lesser sentence in this case. Once that law is changed, then the court can easily just say, okay, we can reduce the sentence to something that's more appropriate. Right now, that they can't. Like, they're bound by law to change to pretty much 20-year sentence based on the crime that she was convicted of. And it's really too late also for the prosecutor to go back and try to charge her with a lesser offense because she's already been convicted. So then there's the third option, which is going to the governor and having a pardon issued or her sentence commuted, which I think it's a kind of a long shot. Just the political party and persuasion of the governor, but not impossible, given that, hey, there would be some people, even within the governor's own party, that would pretty much strongly side with Miss Alexander here, even though if there's others that would pretty much oppose that. There's ways that political pressure can be applied, and this is kind of where all the popular outrage could actually be channeled towards that. I'm not exactly happy with them trying to compare this to the Trayvon Martin Zimmerman case. They really are completely separate things. Year prison sentence, and if enough pressure can be put in, like popular outrage at this outrageous sentence, and it could trigger the governor to commute the sentence. And she's already served about 2 years, and reasonably, even if a governor was perfectly willing to commute a sentence, it would still be like, say, at least another year before that actually happens. So like a 3-year sentence. There you go, what she was originally offered to begin with. So that's then Trayvon Martin angle, and just focus on, okay, she's served, if she's guilty or not. Even if she is guilty, she served more than enough time than the crime deserves. So commute or pardon. Some people might ask, okay, well, can President Obama do anything about it? Well, this is a state matter, so he doesn't have the direct power to pardon Mrs. Alexander, but what he can do is exert pressure on the governor to issue that pardon, and like a direct request from the president. Just given the whole outrage of enough people sign petitions, then all of a sudden now it's not just the president saying commute this sentence, it's the people that are saying it, and the president's just the one that's delivering the message. And for anyone that says, well, this is a state matter, like he shouldn't even be mentioning, like, getting involved in this, like the whole union debacle in Wisconsin. Like, Obama makes one statement about the issue, and then all of a sudden people jump down his throat saying that it's inappropriate for the president to be interfering in something that's purely a state matter. Well, I'd say, like, so what? This is a national issue. Like, people around the country are learning about this issue. If somehow he can just make that phone call, or even just make that public appeal to, one, issue this pardon from the governor of Florida, and for the legislatures of Florida, or all state legislatures, to be honest, relook at the mandatory sentencing guidelines. Like, what are mandatory sentencing guidelines? Do they work? Do they need to be tweaked? Like, there's obviously cases that don't deserve to spend, people that don't deserve to spend 20 years in jail, that are spending 20 years in jail purely because of legislative encourage the electorate and the governments of these states to change these laws so that cases like this don't happen again. I think that would be perfectly reasonable from a presidential standpoint. Could even be an issue that he could actually turn to an advantage and say, you know what, I'm willing to lead. I see an issue, a problem in this country, and I'm doing what a president should do and not like dictate to the states, but pretty much be the voice of the people of this country to advocate change. It's like we've done it before many a times. We wouldn't have any civil rights movement was done not just by court rulings and constitutional amendments and laws, but really the president actually going to the governors of these states and having heart-to-heart conversations with them. So I think that is a potential angle, but the one requirement is that, hey, people, if they're outraged at this 20-year prison sentence, that they send petitions, they put pressure on comparison. I doubt that's going to happen. I think they're going to try to carry this Trayvon Martin thing. That's not really fair, and it's not fair to Mrs. Alexander to actually do that. The real issue here is not even disputing whether she's guilty or innocent. Like, based on the facts, she may well be guilty. The facts have been revealed via the news and via court releases. She may well be guilty, but she may not. She may have been perfectly justified. That's just not the issue. Regardless, 20-year prison sentence, too long. And that's where the focus should be on. It's just, okay, it's over, the trial's over. Let's focus on getting this 20-year sentence reduced to something that's a lot more reasonable, something reasonable would be pretty much the time she's already spent in jail. So this posting's gone on for a while, like a little longer than I expected, and this is my first kind of actual video blog about a current event issue. So I will try to be less long-winded in the upcoming postings. But yeah, this is MJ's video blog, and I'll be blogging about other. If it's relevant to my existing company, it'll also be cross-posted on my company website. So I look forward to blogging more in the future. Feel free to post comments both about that topic, the subject matter, and also like feedback on my video, blogging, recording, just giving me pointers. I definitely appreciate the feedback that helped me make May 4th, 2012. Thank you, and have a good day.